Ohio with the Honorable Steph Myers Society is now set. Please be seated.
Good morning. Welcome to the First District Court of Appeals. We have one case on the docket to be argued this morning, and that case is State of Ohio versus Carter. Mr. Hoffman is here on behalf of appellant. Ms. Wood is here on behalf of appellee. Mr. Hoffman, you'll have 15 minutes this morning. Would you like to reserve any time for rebuttal?
I'd like to reserve 8 minutes for rebuttal.
All right. You're testing my math skills this morning, aren't you? I will keep your time, and whenever you're ready, you may begin.
Thank you. May it please the court, Ms. Wood. I'm David Hoffman. I represent Mr. Savos Carter in this case, and this is an appeal from a conviction for resisting arrest. On October 11th of 2021 at Winton Terrace, Officer Anthony Dawson was parked at near a van that was illegally parked. It didn't have a license plate, and he was preparing to have the van towed because it was apparently reported as stolen. And he was approached by my client, and a sort of a friendly conversation took place until Officer Dawson asked my client to lie on the ground and took his taser out. And my client didn't comply with that instruction, and he was told that he was under arrest. A lot of time went by. It looked like a stalemate on the body cam. It looked like the two were bargaining with each other, and eventually, when my client was seated on the ground, the officer used the taser and shot my client in the back, and it looked like my client was going to get up again, and he fired again, or at least he entered apparently you can, after the probes are in the person, you can repeatedly enter a shock, and it looked like he did that twice after the first shot.
Do you recall if the officer took the taser out before he asked your client to lie on the ground, or after?
I thought it was during the command. I think that in my brief, I actually break up the quote in brackets where I indicate that the taser was taken out. And so it's halfway through the quote in my initial brief. And so my argument is that that this wasn't a resisting. In order to resist arrest, you have to be under arrest first. And I'm arguing that all the elements of an arrest were not present at the time of the resistance. I'm arguing that the arrest was completed according to the trial court's findings. It was completed at the time the second officer arrived. This would have been less than a minute after that final jolt that was delivered. And the backup officer arrived and put the handcuffs on, no problem at all. And because there was no problem at all in putting the handcuffs on, I'm saying that at that point, you didn't have any resistance. No force was being used. No force against him was being used. The handcuffs were put on with no problem at all. And so because of that, I'm arguing there's no resisting arrest. The officer never put a hand on him. He pointed a taser at him, at my client, but I'm arguing that doesn't constitute force. So under the Hodari case I cite in my reply brief, there wasn't a seizure, there wasn't an arrest until the end of the story. And so I'm arguing that is the reason why the trial court erred in finding that there was a resisting arrest. And if there are no further questions, I'd like to reserve the remainder of my comments for the rebuttal part of the argument.
All right, you will have 11 minutes remaining.
Very good. Thank you, Your Honor.
Ms. Wood?
Good morning, and may it please the court. Mr. Hoffman, my name is Connor Wood. I'm one of the assistant prosecutors to the city of Cincinnati, representing that same entity. We are here today for a case in which Savaz Carter was convicted for resisting arrest. We are arguing that his conviction was supported by sufficient credible evidence and was not against the manifest weight of the evidence, and therefore this court should uphold the trial court's guilty finding. Part of what we're dealing with here is, in the context of resisting arrest, are these questions of use of force and when the arrest was initiated. So I'll start with when the arrest was initiated, because that kind of determines the rest of the argument here. At the point that Savaz Carter was ordered by Cincinnati Police Officer Dawson to lay down on the ground and put his hands out to his side, at the point that he was informed by Officer Dawson that he was under arrest, Savaz Carter was under arrest and was not free to leave. Part of whether or not a person is under arrest...
He never said you're under arrest, did he?
That was part of the interaction. It was, lay down for me, put your hands... You need to lay down on your face through the taser, put your hands out to your side. And then there was, during that course of the interaction, Officer Dawson did state that Mr. Carter was going to be placed under arrest. The question of whether or not a person is under arrest, it can be effectuated by two different circumstances. So first off is that, as in Hadari, that touching, that physical contact between the officer and the suspect that places that person into custody. The other part of it is whether or not a reasonable person would understand, based on the officer's conduct, that they are no longer free to leave. In this case, it's very clear, even if Officer Dawson did not say the words, "You are under arrest," which is not a requirement in the first place, that the order to lay face down on the ground with his arms out to his side, that's not a position to be ordered to place yourself in such that you would think, okay, I can get up and leave at any point in time. Withdrawing the taser is a show of authority on the part of the officer, which indicates the potential consequence should that person not comply with the order to lay face down. A reasonable person in those circumstances would understand, I am not free to leave under any circumstances, I am under arrest. So we're arguing that at the point that Officer Dawson made that command to lay down, at the point that he withdrew his taser, Savaz Carter was under arrest. From that point is when you get into, okay, what constitutes the resisting after Mr. Carter is placed under arrest? So resistance, in 9 out of 10 situations, you think of physical resistance to the arrest, pulling away from the officers, refusing to be placed in cuffs, requiring additional officers to exert physical force to restrain someone. In this case, the unique situation is that there has been distance placed between the officer and Mr. Carter. But distance in this case does not create a difference in terms of resisting arrest. Resistance can be passive, meaning refusal to comply with an officer's instructions in a situation that requires the officer to exert additional force in order to maintain custody of that defendant. So conduct of the person being arrested or the person who has been placed under arrest that forces the officer to increase the use of force in order to maintain that person's arrest. In this case, what you have is Mr. Carter was ordered to lay face down on the ground, put his arms out to his sides. He refused to do that. He got down in a crouching position such that he was able to shuffle from side to side, move around. Officer Dawson, for a period of, I believe, about 8 minutes, held Mr. Carter at taser point and was moving with him. The point in which Officer Dawson increased his use of force was when Mr. Carter pushed off of the ground as if he were going to get up to run away. If Officer Dawson had allowed that to happen, Mr. Carter may have taken off, may have bolted. He would not have been able to maintain the arrest, maintain the custody of Mr. Carter at that point. So Officer Dawson deploys his taser. That is an increase beyond just the showing of the taser, that show of authority saying get down on the ground as an officer, that would put Mr. Carter on notice that he's not free to go anywhere, that he's under arrest. The deployment of the taser was the increase in the use of force necessary to maintain Mr. Carter in custody until the point that backup officers were finally able to arrive on the scene and place Mr. Carter into handcuffs.
Counselor, could you please address the defendant's argument that the complaint was deficient because it filled in by force rather than recklessness? And and that because it wasn't amended, it's deficient?
Yes, Your Honor, I can. So part of what we were talking about is the definition of force and how that is used.
Is it the defendant's force or is it the officer's force? Because what the statute says is no person reckless or by force. So that seems to me it would be the defendant.
The statute would read as if it were the defendant. I would say that is true. In this case, I would argue that Mr. Carter was both reckless and did resist by force. The reckless part is obvious, refusing to obey the officer's instructions such that, getting up off of the ground after being instructed to lay face down, refusing to comply with those orders, that is reckless conduct, especially once he's on notice that he is under arrest and not free to leave. That affirmative action in getting up to run such that it increases, or it forces the officer to increase, I'm using the word force a lot here, but forces the officer to increase their use of force to maintain that person in custody. That affirmative action, in this case, we would also argue constitutes resisting arrest. That is conduct that he is engaging in. It's an affirmative act in pushing himself up off the ground. I believe the two subsequent taser deployments were because he was either attempting to get off the ground again or because he was reaching towards his waistband. Those affirmative actions, in this case, would be force that, the officer responded in kind in order to maintain Mr. Carter in custody. So we would argue that the complaint is not deficient.
And one more question. Was that an issue that was raised at trial?
It was not. Not to my knowledge, that it was not raised at trial by the defense nor by the state. There was no motion to amend or anything along those lines. And the court did find that there was a sufficient evidence based on the complaint as it was written to sustain that guilty finding.
Well, and let me just ask a follow-up. The statute, it was charged under the correct subsection of the statute. It's just that subsection has two elements, reckless or force. I mean, he was charged and convicted under the same statute.
Yes. So we would argue that Mr. Carter's conduct in this arrest and what he did during the arrest that forced Officer Dawson to deploy the taser, increase that use of force, that is resisting, even though at that time there's no contact between the body of the officer and the body of Mr. Carter. That taser sort of acts as an extension of the officer. That is an application of force in this case.
Was the use of the taser needed in order for there to be a resisting arrest in this case?
The use of the taser specifically, I would say no. If Mr. Carter had gotten up and Officer Dawson put the taser away and...
That's the only fact that gets changed. If the taser had not been used and everything else that had occurred, would there still be a resisting arrest?
Given the facts as they were, I would say likely not. Because again, you have this idea of if there is passive resistance, it has to, do one of two things. It has to either delay the arrest itself, or it has to force the officer to increase that use of force. If you don't have the taser deployment without something else changing in the fact pattern where Officer Dawson does exert force based on that passive resistance, then potentially no. because this is one of those rare situations where there is passive resistance. In terms of passive resistance, this court, more recently in the King case.
Is it because it's passive resistance, or is it because there was a finding of fact that there was no delay?
I would say it's both. The finding of fact that there's no delay when this is a case of, actually, let me back up. The fact that the court found that this was passive resistance, I think necessitates a distinction between whether or not there was a delay or whether or not the officer was forced to, or whether the officer had to exert additional force. Because that is the case law for passive resistance. It has to be one of those two scenarios. So the finding that it didn't delay, when we say delay the arrest, in this case I think it would be more appropriate to phrase it as didn't delay the application of handcuffs per Cincinnati police policy, which Officer Dawson was following at that point. But in terms of whether or not it's because it was passive resistance or because there was no delay, I would say you have to answer whether or not it was passive resistance first and then determine whether or not there was a delay or that exertion of additional force. In this case, the court found the latter. And as I was saying, in the King case here, this court, as recently as 2019, that was one of the few passive resistance cases that I was able to locate in researching this issue. And that was a situation where it was even, I don't want to say less force to minimize the issue, but that was just a situation where a person was refusing to comply with an officer's orders. They were, making a scene in a public space. The officer ordered that defendant to place their grocery bags down, to put their arms behind their back. That person refused to do so. And this court held that the action of the officer in taking the grocery bags and then physically placing that person's hands behind their back, they said it was a narrow holding or a fine line, I should say, to cross, but they did find that that was sufficient to constitute passive resistance of arrest because, again, the officer had to exert additional force in order to place that defendant into custody. Same situation here. Again, you're adding distance, but you are not adding much of a difference in terms of when the arrest was effectuated and how the passive resistance qualified as resisting arrest. So again, Your Honors, we would ask that you sustain the conviction in this case, that you affirm it. This conviction was supported both by the sufficient evidence and was not against the manifest weight of the evidence. And if Your Honors have no further questions, I will take my seat.
Any other questions? No? Thank you. Mr. Hoffman, you have 11 minutes.
Thank you, Ma'am. I'd like to begin by attempting to clarify my comments about the complaint. The only case I could find on the subject was a 1970 case that I think was based upon notice. And it's kind of hard to argue a misleading or a notice issue when it wasn't even noticed below. And I'm just noticing it for the first time. But, and also that really wasn't what I was trying to get at. What I was trying to say is very simply, that and I mentioned this in a sufficiency claim, I'm saying that if you have more than one way to violate a statute, and in the complaint, you limit yourself and you pick one, and you say that's what the person did, then that's what you need to prove. And that's all I'm saying.
You mentioned a 1970 case that was probably before the criminal rules of procedure. And as long as the identity and the name of the crime, I'm dealing now with a felony case, don't change, I mean, what's the argument? He was charged under the correct statute. He was convicted under the statute. It's an either or. He was on notice. There were, cameras. What's your argument? That he didn't know recklessness could be an element?
No, I guess I was putting a little bit undue importance on the complaint, I guess. I thought that what is the case was what I said, that
and I'm not saying it isn't, I just want to make sure I understand your argument. Your argument is because limited it to one of the two ways of proving it, that they're stuck with that. They, the state, are stuck with that.
That's all I'm saying. And
But it wasn't raised below, correct?
that is correct, yes.
Okay.
And
So would we have to view it under a plain error review?
oh, well, actually, no. If I'm right, it would be a sufficiency claim. I mean, it would be a lack of evidence of force. Am I making sense?
I think what you're saying is they're limited to recklessness is out of the picture, force is the only thing, and the evidence was insufficient to show force.
Yeah, I'm not
Even
saying
if
that-
it was sufficient to show recklessness.
Right. I'm not saying the complaint is deficient in any way at all. I'm just saying that the proof didn't match the claim.
Okay.
That's all. And if I'm wrong, then, I'm wrong. But I noticed it, and I thought I'd point it out, and I'll move on. The Hodari case has two tests. One is the actual force. When is there a seizure? Well, the officer could put his hand on a person. There could be force that would cause a seizure under Hodari, or it could be a show of authority and submission to the authority. And the test is not, whether a person thinks they're free to leave or not. That's morphing it. That's a different test. My use of Hodari was that in this case, you didn't have an exertion of force upon the person. You had commands to do things that weren't being complied with. You had, he was pointing a taser at him. He was told he was under arrest. All these shows of authority, but there wasn't a compliance. There wasn't a submission to the authority. And those two have to be present for there to be a seizure under a Hodari.
But in a resisting arrest situation, wouldn't that always prevent it from being a seizure? I mean, if somebody is not submitting and they are resisting arrest, wouldn't that by definition always prevent it from being a seizure under what you just said?
Well, a lot of resisting arrest cases would be physical, I would think. You'd have the hands on and the person would pull away maybe or something like that. There you'd have the force applied and you'd have a seizure and then a struggle against that seizure. In this case, it was different. There was nothing physical. They were all commands, verbal commands that weren't being complied
But the
with.
taser was physical.
Well, it became physical when he shot him with it, yes, Your Honor. But before then, he held it at him. It was I would analogize it to a command. I mean, until you pull the trigger, it's just a threat.
But if he had hopped up, if he really was getting ready to hop up, and he had hopped up and began to run, and then the taser was deployed, would your argument be different?
So if he was shot in the midst of fleeing, I mean, in the
Yeah,
process of
if he
fleeing.
got further, if the officer was correct, that he was pushing up to run, and let's say the officer didn't deploy his taser as quickly, and your client actually picked himself up and began to run, and then the taser was deployed, would your argument be the same?
Well, I guess I'm agreeing that the use of the taser in any event is going to be the application of force.
And is he resisting at that point? If he's running away and then the taser's deployed, under your argument, would he be properly charged and convicted of resisting?
The attempt at flight would have happened before the use of the taser, so it would have been before the force, and so it would have been before the arrest. I don't know. That's one way of looking at it. If the force is necessary in the recipe for an arrest and it's not there at the time of the resistance, then maybe there's no resistance of arrest.
But then isn't Judge Bach's point, there would never be resisting arrest? Because the person's never totally under control when they're resisting.
I was just thinking that as I sat there, that can become circular, I guess. The point that the call for the force is the very thing that might be the element of the resisting in many cases. But I still think that in this case, the facts are so strange. For example, the first command to get on the ground came out of the blue. I guess the officer might have assumed that this person knew they had a felony warrant, maybe. I don't know. But in the midst of the discussion, he just told him to get on the ground, and it was kind of strange.
Well,
And,
wasn't it because he had run the VIN number, found out that it was stolen, and then your client was planning on moving the van? I mean, said he was going to move it?
I'm not saying that he didn't have a good reason to arrest the man. I mean,
Okay.
He knew he had a felony warrant. He knew he was associated with that vehicle that was reported stolen. And there was a lot of back and forth about how he tried to talk his way out of being cited for it being parked illegally and all that. But still, it seemed to be like it seemed to be out of the blue, the command. And I'm not excusing my client's conduct as far as the refusal to obey the command. But it's a little bit understandable, his hesitation to lie flat down on the pavement, face down, out of the blue. He was just asked to do that. And then here comes the taser right away. And buddy, you're under arrest. And no explanation at all. And so you had this resistance. He sat down. It's just that he was reluctant to actually, I guess, I don't want to, it was demeaning, and especially without the explanation. And but he did have the felony warrant. I'm not trying to, say it was wrong what he did, or right what he did, but he should have gotten down on the ground face down. But the fact that it was so out of the blue makes this all kind of unusual. And the officer's continuation of the negotiation for 6 minutes is unusual. It's almost like there was not an arrest. It really does seem like there was a stalemate, a bargaining going on to achieve this person's compliance.
But isn't that a good thing that the officer didn't immediately deploy his taser and was trying to get your client to comply without the use of force?
Sure, yeah.
And that's not, the fact that it was an 8-minute standoff is not necessarily a bad thing.
Not at all, not at all. And it's understandable that he wanted somebody else there before he forcefully put handcuffs on the person. The policy is a smart policy to make sure that you have 2 officers there. One person to keep an eye on the person while the other person's busy putting handcuffs on him. None of that, I don't have a problem with any of that. It's just that at the point that the handcuffs were put on, this person was fully compliant. He was on the ground, his hands were behind his back, he did everything. I mean, he could have run, but he didn't run. He was there to be handcuffed at the time the handcuffs were put on. And I'm saying that if that's going to be the point where the arrest was complete, he didn't resist. And so if the court would consider that, and I'm asking that the court would reverse this conviction and discharge my client. If there are no further questions. Thank you.
Thank you. Thank you both very much for your arguments this morning. That will conclude the arguments at the First District Court of Appeals. We will take the case under advisement and give you a timely written opinion. Thank you.
All rise. The Court of Appeals, First Appellate District of Ohio is now